Welcome to Channel AMAC, your insight to the Australian visa system. Good day everyone, my name is Carl Young, your online YouTube visa consultant. Now in this video, I would like to discuss in regards to the inherited assets that you could possibly used for the designated investment under the 1AA investment stream business investment visa. Now, as you know, 1AA is predominantly used for a lot of highly experienced investors or business owner to actually migrate to Australia, utilizing investing into government bond. Now, because it's a government bond, there is a certain restrictions. Now, the rule and the background of the design of the visa is to find out the applicant or the candidates who has actually been highly experienced in investing products or services or financial assets in regards. So the way they find the way they want to tailor it is that they want these highly experienced investors to come and settle in Australia, and potentially they will continue to invest more assets into Australians market. So there is a certain source of fund required, which is different than the 188C, the SIV visa. Now the difference is basically 188C SIV doesn't require you to demonstrate any kind of experiences as long as the fund provided is lawful and legally obtained. So it can be inherited, it can be gift from someone else or someone related to you, as long as it's legal, lawful, and nothing, and can pass the international anti-money laundering law. So there's not much of requirement to demonstrate the experiences for 1AA. That is the advantage for 1AA. But 1AA is totally different because it's seeking for a candidate who has a highly experienced and qualified investor. So they wanted to make sure the rules are set up in a criteria to actually filter these candidates for the bond investors. And let's take a look at what it actually has in there. So first of all, let's go into the actual immigration's web page, which you can always find in the Home Affairs website. So this is specifically picked for 1AA subclass investor stream already here. So once we click on eligibility, where we could find the own and manage business personal assets, in my previous video has already explained this part, and obviously asset, it has to be at least 2.25 million Australian dollars. That's including your own living properties and all that other stuff in there. Now the thing I want to discuss, I want to go dig into the detail, is this part here. Now it may seem pretty clear and direct. By means they said, oh, just make a 1.5 million Australian dollars to nominate the state or territory into the state or territory bond, treasury bond. That's no brainer. But there's a sentence here. It says this investment must be in your name or in your name or your partner's name, and the investment must be made from unencumbered, which is not a problem. It cannot be a fund borrow or loan or mortgages, but it has to be fund generated from qualifying business or eligible investment. Now this is the key. This is the detail that I want to dig in there for this video today. So what that basically meant is the fund, the 1.5 million, has to be an earning some sort generated through years of your business or years of your investment activities. It cannot be a fund like what 1AA SIV, just to be a fund sourced or obtained or given or inherited from your parents or friends. So it has to be demonstrated that the fund is actually coming and generated from a qualifying business and eligible investment. So let's go into the actual regulation here. Now, the regulation is actually, let me twist this a bit over here. Okay, now, and magnify a little bit. Okay, here we go. I think that's more readable now. The thing that we wanted to focus on is the regulation 188.246 today. It basically said the title is pretty clear. Now, you need to inject 1.5 million as what they call designated investment. That's no brainer. But number 2 here, the sub-regulations here says the fund used to make designated investment mentioned in subclause 1 were A, unencumbered, not a problem, and the details here we wanted to discuss the B, accumulated from either or both, so either 1 or either 2 or both. Okay, so accumulated from one or more qualifying business conducted by the applicant or applicant's spouse or de facto partner or applicant and his or her spouse. Anyway, I think that whole thing basically meant you and your partner. Okay, you and or your partner. That's it. Okay, and 2, eligible investment activity of the applicant basically mean you and your partner's investments. So it has to be derived and accumulated from there. Now it doesn't require the accumulation to be within that 12-month period before you get invited. So it can be a long-term accumulations. So anyway, the document, the supporting document required to demonstrate that will be basically what I generally do is I get the applicant or candidate to have a resume, a CV describe how you have, when you have become professional investors, and then continually your activities and business so on within a CV, and that is more precise for the case officer to understand how you have become a experienced investors. Now, saying that, let's go into the actual policy, the detail where the CEO, the case officer, actually reads. So it's within the PAM 3 where, let's have a look up right here, where it says ownership. You see from the screen on the in the middle of the screen, it says ownership and source of asset or designated investment. So basically, here we go. It says the intention 188.246 ensure that the fund deposit in the designated investment were generated through qualifying business or eligible investment activities from the app you or your partners together accumulated over these periods. So, and we're not in an illegal activity. So illegal activities basically mean it's not stolen, it's not cannot use a illegal gambling profits and things like that, and it's not borrow. So that's basically says it all. And also it says in scrutinizing when the case officer scrutinizing ownership of source fund, they are looking for that the fund were not sourced from these activities. So if a case officer feel that the fund is not from a business or from your investment activities, meant it can be inherited or other windfall or illegal activities or things like that, they will go into a detailed scrutinization where they wanted to ask and require you to demonstrate with additional evidence of support to prove that these funds actually derive from your qualifying business or eligible investments. And that's a hard bit. So don't think that you have the money, you can actually do 1AA-B straight away, because 1AA-B, as I said, it's intended to seek for experienced investor or experienced business owner. Business owner is also an investor as well. Anyway, so here we go. The fund unencumbered. That's the no-brainer. Basically, man, it cannot be a borrow fund or any kind of loan from bank or from other personnel and things like that, and supporting documentations require to be provided. So generally what I do is you need to get all these supporting documentations prepared before lodgement, or even prepare before putting in your experience of interest. Now, obviously, we do have professional services to assist with your application. If you do, you can consult with me if you want. But also, if you have your personal migration agents or lawyers, seek for their assistance. Okay, now ineligible fund here basically it spells out that it cannot be a financial windfall, including gambling. Obviously, you cannot go into a casino and earn a couple $1 million and take the proceeds and then go, because that doesn't count as an investment experiences. Now, the key here I wanted to talk about is also the inherited asset. Now, it's very interesting where it says here, it is open for an officer to include certain inherited assets, having regarded such factor as the proportion of the asset were inherited, or the proportion of applicants' total asset were inherited, how long ago the asset were inherited, and the value has been added to the assets since inherited. And reading on, it says, even if the inherited asset is excluded from consideration, any return achieved on original value of the asset may still be included. Interesting. So what does that chunk of wording actually mean? Because a lot of times that people come and ask me is that, well, I understand English, but when I read these legal sentences, they cannot grasp the actual logic behind it, and sometimes and a lot of time, in fact, I have to read it 3, 5, 10 times to actually get myself, get my head around it. So let me explain to you what this chunk of words actually meant. It means that, giving you a scenario, applicant or candidate is on his mid-40s. Now, he or she was inherited with a lump sum of possibly $1 million 20 years ago when he graduated. He got the money. He got the asset and funds from his parents or grandparents, and he or she utilized these funds to invest into stock, bond, and perhaps she take partial of the fund to invest into businesses. And during the past 20 years or 15 or 10 years, she had made profits, returns out of the stock she invested it, bond invested it, and also her business has continually been successful over the past 10 or 15, 20 years, and obviously making money out of that. So in this scenario, she had utilized $1 million, and over the past 10, 20 years, and made over $3 million. Perhaps, I'm just making an example here. Now, these are the returns made from the inherited assets, and this is eligible, can be used under this scenario. And in fact, there are a lot of candidates and friends and people that I met, and they are like this scenario. So basically what that policy had just demonstrated is that a lot of people saying, look, gosh, this money is so inherited and so in my business and things like that, so it cannot be used. No. You use the money wisely, and you have invested wisely, and obviously over a period of time, your living standard has increased. Obviously, you have been a successful investor, successful business person, experienced investor, experienced business person. Then obviously, that's the candidates the immigration is seeking for. Now, that concludes our video today. Should you have more question or query, more than welcome to leave a comment right down below. And finally, I'll ask you to consider subscribe to my channel, so once we have more Australian visa insights or information, you shall be the first one of getting these info. I see you in the next video. Goodbye.